started with the session today. This is our workshop on ODP rate appeals. Thanks for joining us. My name is Craig Douglas. I'm here with Patrick and the Provider Alliance. Just a couple quick housekeeping items. We're recording the session today, so as usual, we'll provide a follow-up with any of the attachments and materials that we covered for today. We'll be using the chat and the Q&A to post anything to you. So we'll have an announcement link that we'll send in the chat, but feel free to use that to communicate with us if you have questions. It's a relatively small group, so if you'd like to raise your hand, we can certainly unmute your mic so that you can ask your question directly. So with that, again, welcome everybody, and I'm going to turn it over to Patrick to get us moving.
Thank you, Craig. Welcome everybody. Thanks for being here today. So we are going to cover some information on ODP rate appeals, the process to do that. So if you go to the next slide, Craig, I'm just going to briefly kind of lay out what we intend to do over the next hour or so. So I do want to say that we will be joined by Travis Geary in the session. Travis is the attorney from K&L Gates who has handled the current and previous rate appeals by TPA members. There are many other attorneys who do that as well, but we've had a relationship with K&L Gates for several years. We're also going to have some members share some experiences and some information as well that we've shared with members before, but one of the intents of this session will be to kind of tie everything together in the context of a rate appeal, what you should consider. And even if you're not interested or decide not to follow through with the rate appeal, we just want to provide information. So hopefully at the end of this session, you'll know a little bit more about the process, some of the things that may arise as potential arguments that may be used in advocacy as well. So with that, we intend to obviously look at the fee schedule updates that have occurred since the publication of the rates. If you joined us on August 30th, we had Rick Smith pretty much in his final week of employment with ODP. There were many errors, as it turned out, in the published rates. So there was a publication last week. We'll touch upon that. We will provide some background in terms of where we are with this current fee schedule. We will go through some considerations that we think are important. And again, we will talk about some provider experiences, the perspective of people who have done these appeals in the past, and the procedural requirements, what you really need to know in terms of filing an appeal, and what are the deadlines and the scope of the appeal and those sorts of things. So that is what we intend to cover this afternoon. So with that, Craig, if you can go next slide, the first place we want to begin. And I think Craig's going to post this particular announcement, 24087, into the chat. This is recent, I believe, middle of last week. And the takeaway is ODP has made corrections to the following rates in the consolidated community living and person family directed support waivers. So community participation support rates, we noted this really pretty much as they came out. There was an error in the calculation of the CPS rates. By now, many of you know that, particularly if you were providing CPS services and you looked at those rates. So those have been corrected. There was also a question about life sharing without day being at a lower rate than with day in some instances on the fee schedule. So everything has been corrected. And there was also some changes that were made. ODP corrected the tables for the following services in the adult autism waiver effective July 1, where different rates were published in the procedure code and statewide fee column. So if you go next slide, Craig, you can see that list. And again, this is right from the bulletin. You can open this up and read the entire ODP announcement. But the corrected and final fee schedule rates and department established fees are at the link. You can go there, you can confirm everything, and by now you may have done that. But that is the update in terms of what has happened since we last spoke about fee schedule rates, which was very recent. August 30th was the last time we touched upon rates, and we went through what was published on that day. And of course, the fact that there were errors was an unexpected surprise. Those have been corrected by ODP. So one implication, and you can go to next slide, Craig, as I kind of wrap this up. The department, and it's noted in this announcement from ODP, they will indeed republish. So we will get into some of the implications of publication date. Publication date affects the time period for which you as a provider have to file an appeal. So Rick had said this when he joined us as well on August 30th. He expected they would republish. They have confirmed they will republish. We checked on this past weekend. They did not republish rates. So they are still forthcoming. That will determine appeal rates on the new CPS rates as published, and we don't yet know if they are going to publish the entire fee schedule or only these rates that they reference in the ODP announcement. So as far as providing some background, $280 million to help raise wages. We've flagged that. Again, this is a piece of information we've used. This is directly from the governor's press release. On or about July 11, 12, once the budget was enacted, we had final numbers. We knew they were less than had been requested in the governor's proposed budget. So $280 million is what was announced rather informally, although it was in a budget press release. If you go to next slide, you will see the fiscal impact. And this was as published on August 30th. Technically, the publication date in the Pennsylvania Bulletin is Saturday, August 31st. But this is an excerpt that shows the $280 million. You see how much of that is state-only money. There's federal matching involved in these rates because they are home and community-based service Medicaid rates. So you can see the tie-in to the $280 million. If you go next slide, we got some background within the text of the publication. So there was a good bit of new information that we believe is relevant to the appeal process. So the first thing that we note here, and this I believe is in the first paragraph of the publication, again, this is the August 31, you can find this online in the Pennsylvania Bulletin. The department is required to fund services within the amount of funds appropriated by the General Assembly. This is new language. If you go next slide, please, Craig. The rate setting methodology, really sort of reflective of this also, you can see where it's in red, where rates were established by applying an inflationary adjustment factor of 8% to the rates for non-residential services, 6% to the rates for residential services. Now, this was not unexpected, but we did not expect them to state that they were deviating and creating a new methodology. So if you go next slide, Craig, the next thing we wanted to point out was the state always publishes a methodology. As you'll see in a moment, they're required to publish a methodology under regulation. And if you go back just a few months, when the proposed rates that were not enacted were published, a rate setting methodology looked very different. This is what was published then. And you can see mirroring language from current regulation. Fees were developed using a market-based approach. They go into some detail, including a review of the waiver service definitions, allowable cost standards, which reflected costs that are reasonable, necessary, and related to the service, cost principles, and audit requirements for federal awards. So a lot of language really drilling into how the department determined the cost of services and how that would translate into their fee schedule rates as a methodology. So this continues on the next slide. So what I wanted to call out, and it's just the final couple paragraphs of this, this part of the announcement that addressed rate setting methodology, they tell us beyond what is in regulation, the department evaluated and used various independent data sources, such as a Commonwealth-specific compensation study to ensure the rates reflect the expected expenses for the delivery of service. And it also references specifically Chapter 6100 regs, specifically 6100 571B. And if you go next slide, Craig, what I've done here is rather than what the bulletin announcement does is kind of list out section B here. This is the actual regulation. So it does not call out all the regulation in the published announcement of the methodology. It also adds a little bit of other language, talks a little bit about some of these elements, about following federal rules and procedures and those sorts of things. But this is the actual regulation. I know this is a bit small because I wanted to get the entire regulation onto one slide. As you can see, A, B, C, and D. B are really the 10 elements under regulation, and methodology is always mirrored regulation. So these are the 10 elements we're very accustomed to looking to. These sort of establish the basis upon which provider appeals are filed. So also just wanted to call out the rate setting methodology, section D. Notice will be published in the Pennsylvania Bulletin for public review and comments. The description will include a discussion, the use of the factors in subsection B to establish the fee schedule rates. So where we stand today, actually none of that was done. So we heard from Rick, and we've read it here today, the methodology has been the application of an inflation factor. While we think that's probably positive news that we can work with going forward, it is not in alignment with current regulation, nor is the statement that the department must fund rates on the basis of the appropriation. There isn't anything that prohibits states from doing that, but in Pennsylvania, that has never been the case. That has never been written into statute or regulation. So next slide, Craig. So we want to talk a little bit about the scope of appeal. So we're all very familiar with published fee schedule rates, and we've been using those rates, but also in this publication is the fact that the payments for residential tiers, so tier assignments under performance-based contracting, have a reference written into the published notice. So select providers will receive a rate add-on of 3% per individual served, and clinically enhanced providers will receive a rate add-on of 5% per individual served. So we probably all recall previously, these were higher add-ons at 5% and 8%. So just calling out that as a published announcement that is actionable for appeal, this also falls within the scope of the appeal process and what ODP would receive, we expect, in terms of filing a rate appeal. Also point out that the fiscal impact, the numbers we looked at earlier, are inclusive of performance-based contracting. So there is not a separate line item anywhere in the budget or now anywhere in the way that ODP looks at these things financially that segregates out performance-based contracting. If you go to next slide, we'll talk a little bit about pay for performance. So similarly, in addition to the tiers, this is the language published that speaks about pay for performance. And it remains vague. We don't have any more detail on this as of today. But we'll receive one-time or combined payments up to 3% of ODP eligible service revenue from the applicable review period or established payment amount per qualifying event. Established payment amount or qualifying events, we really don't know what those are at this point in time. Another incentive that remains is the transition to supported living or life sharing payments. But you may have experienced this. You may have cost information that indicates that it costs you more than the reimbursement or the incentive. So we just want to call out, in addition to the actual fees, there are other elements in the publication that can be evaluated in terms of the consideration of an appeal. So next slide, please, Craig. So there's a couple of things we've been calling out for a while now, ever since we received the rate assumptions that were published when the fee schedule rates were published as proposed in April. We also obtained through right to know request the Mercer report, so the actuarial analysis, much more lengthy and detailed. And Craig, I don't know if we have Tom Krofcheck. I know he did some of this work. I was going to add Tom to the conversation. Hi, Tom. Welcome. So I again want to acknowledge that Tom has been the chair of our financial management committee at TPA. Yeah, you've had a couple sessions recently, Tom, I know, and you've really taken a dive into this. And after we received the Mercer report, Tom took a deep look into it along with some other members. Tom did a presentation with some TPA member panelists. And a couple of things that I just wanted to touch upon briefly with you, Tom. First of all, the overtime. So we've called this out pretty loudly since it was first recognized. I will say the rate assumptions have been taken down from the ODP website. So you can no longer go look to see what the assumptions were. And ODP, again, has distanced themselves from the fact that they're even using that methodology any longer. We've called that out with some of the comments that have been published here today. So Tom, let me bring you in. I'll let you comment on overtime. You know, it's something that we're going to have a little bit of a conversation about, but just to kind of give it the context that it needs. Maybe I'll just turn it over to you. This isn't the exact slide that you had prepared, but I know you called it out and highlighted some of the text that's on the screen.
Yeah, thank you, Patrick. So when the assumptions from ODP came out, I was actually delighted to see that overtime was an individualized line item, because historically in the past, overtime was just lumped into DSP wages and you couldn't see what assumption was actually used. So for example, in community participation supports, if we were looking at those assumptions, you would see that there was an overtime factor of 5%. Now, I feel like that's a little light for CPS given the DSP workforce crisis, but at least ODP could argue that they did use overtime, and whether or not it was reasonable could be debated. The Residential services, what you're looking at on this slide, is completely different. Here, they are suggesting that there is no overtime. And if you look at the double asterisk, they're saying overtime's only applicable to salaries that are at or below $35,568 per year. This is, in my opinion, ripe for appeal for a number of reasons. Number one, it is simply an incorrect application to assume that a DSP could be salaried exempt simply because they made more than a certain dollar amount. If you look at the job postings that ODP has for their own state center DSPs, you will see they are considered to be non-exempt hourly employees. And it does indicate that some overtime work would be required. And because they are non-exempt, they would be paid that at time and a half. When you consider the rules of the Fair Labor Standards Act, it is crystal clear that there are three components that must be met for an employee to be characterized as exempt, and therefore you don't have to pay them overtime. And one of them is the duties test, and the DSP simply does not meet the duties test. This has been taken up to the Supreme Court, not specific to DSPs, but another situation, and the Supreme Court ruled federally that all three tests must be made in order to not pay somebody overtime. Additionally, the $35,000 threshold that is listed here, about a week after this was posted in April, the feds came out with a higher threshold, over $45,000, if I recall correctly, which was applicable in June 30th. And as we currently stand, effective January 1st, this threshold is going to be bumped up substantially higher. I believe the threshold is increasing by 65% from what's presented here to what will happen on January 1st. And if you fast forward to what ODP decided to do for residential services, instead of increasing rates by 65% or 12% or anything of that matter, they decided to increase them by 6%. And I was so gracious that Patrick was able to get and secure Rick Smith to meet with this group two weeks ago, because Rick went on record and said, well, we did 6 and 8%, and I acknowledge that inflation for this period of time has been more than 6 to 8%. So it just a few factors to consider when appealing. We know that ODP's April 20th rates, although higher than the 6 and 8% that we're getting, don't even comply with the Fair Labor Standards Act. And one of the other components that was on the slide that Patrick showed us of 6100-571 was that ODP is required when setting rates to comply with all state and federal requirements. And FLASA, the Fair Labor Standards Act, and paying people overtime is a federal requirement.
Thank you, Tom. And then we'll go to the next slide. I really appreciated the work you had done in the analysis of the Mercer report. So this is directly from Tom. If you joined us back on August 2nd, Tom covered this in a lot of detail, but I'll let you explain it, Tom.
Sure. So if we go back to the winter, Governor Shapiro ordered ODP to do an update of all of the rates. By regulation, as we've seen in 6100-571, ODP is required to update the rates at least every 3 years, and they must use those updated assumptions to do their market-based rate setting assumption. Now, ODP is not full of a bunch of actuaries, so here they do rely, as they historically have, on an actuary at Mercer to take all those rate setting assumptions that we looked at on the last slide, and they take the low end of the range, and then they take the high end of the range, and then Mercer creates actuarially sound rate ranges. And effectively what happens is ODP slides the scale saying, I expect utilization to be X for this service, and I expect the appropriation from the General Assembly to be Y, and they slide those scales for every single procedure code to find out a rate that is actuarially sound, falling within those assumptions and complying with the 6100s. And that's effectively what they do every year, and that's what they did in April when we saw all of those proposed rates. So fortunately, Patrick was very successful in getting a very timely right to know request, which he shared with all TPA members. And this was an 87-page report that went through and had an appendix that showed every single procedure code, and what the rate was last year, what the rate was proposed to be in April, and most importantly, what the floor of those rates is based on the assumptions that were required by regulation to be updated and that were published on April 20th. So I exported that PDF into Excel, and then I compared it to what the actual rate assumptions or what the actual rates were that were published on August 30th. And it really only matters from a regulatory compliance perspective if the actual rates that were finalized were less than what the actuaries said were the floor based on the rate setting assumptions that by regulation were required to occur. So it is one thing to say, boy, we thought we were getting a 12% rate increase and we're disappointed we got 6.6 or 8%, because that could have fallen within the regulations. But thanks to this actuary report, we were objectively able to say that the final rate setting that came out on August 30th took $121 million out of the system below what the actuary said was permissible based on the assumptions that ODP was required to update. So we're just not filing an appeal saying we thought we were going to get more, boy, we wish we got more, we think it should be more. We say no. The regulations required ODP to update the assumptions. ODP did so. The actuary said you can't go lower than this, and if you do, these are no longer market-based based on the assumptions that you created, and they were below that by $121 million. So just looking through this, you'll see supports coordination, $7.3 million below the floor, companion, $16.9 million below the floor, in-home community supports, over $42 million below what the actuary said is as low as you can go, and then residential services, distinctively licensed residential, about $51.2 million below what the actuary said ODP can do. So I believe that this is really a gift and the roadmap, this Mercer report, to a successful appeal.
Hey, Tom, thank you. It was really excellent work. I appreciate you doing that. And Craig, we may have this recorded. So to the extent we have this, if members are interested in going back, looking at everything that you had done in that discussion with panelists that day, just let us know. It may be on the site. Craig, if you know that, you can maybe just post that it is in the chat. So thanks again, Tom. We may come back to you because we're interested in hearing some feedback from members who might have questions, and some members such as you who have been involved in appeals. So thanks. We'll leave you on standby if that's okay for a couple of minutes here. We'll bring Travis in, our attorney, in a couple of moments also. So we go next slide, please, Craig. Just to kind of wrap up before we truly get into the legal discussion and legal requirements. These are just some considerations that we have put forward that we would like you to think about. So when we talk about specific damages, one of the things you really can't approach in terms of reason to appeal is we want the rates to be higher. We're losing money. These may be facts for you, but in terms of what is really effective and what you really can appeal, you really have to develop a fact pattern. There has to be evaluation of your actual claim and specific damages. So you have to give some consideration, which is why we looked at the overtime assumption as a material flaw. Something that we could point to and say that is just inaccurate. It's wrong. All of you know that you pay overtime if you operate a residential program. We know the state pays overtime to its residential service assistants at the state center. So it's just something that we could point to as being incorrect, that we thought was appealable and that would affect at least all residential providers. Likewise, even the 5% in non-residential, plenty of basis to indicate, and your experience would be critical in terms of moving forward with an appeal. So one of the things I'll cite as an advantage is just that there's an established legal process. Travis will jump on here in a moment and kind of walk through why it is what it is and why you have timelines and why there's a deadline to file appeal. But some of you may have good relationships with the folks at ODP. Now, Rick is no longer there. We really don't know who his permanent replacement is going to be. So that cast a little doubt in terms of if you've worked with Rick in the past. We don't yet know how things are going to work now that he has retired and moved on. There'll be a replacement filling his role. But when there is an appeal filed, again, there's a lot to consider before doing that. It does keep things on an established timeline. It does hold ODP accountable to continue conversations, produce discovery. As Tom and I have noted, we got the right to know request filed. We have the Mercer report, something that would have been gotten through discovery, but through right to know, we didn't have to pay for it. It's on our website. So it gives you a little bit of a head start in terms of evaluating how anything in the rates, the Mercer report, may affect you. And even though I'm going out of my way to say they are changing methodology, I'll let Travis speak to this. We really don't believe that they can do that. Regulation is regulation. Making a comment in the bulletin and publishing a new rate setting methodology really does not align with anything else. So it probably creates a stronger legal argument, but that's really a question and something I would let Travis comment on. I don't want to say really anything more about that. But there is an established process. You'll hear about this from Travis, what's in regulation. We're familiar with our own regulations that govern programs and services and financial, but there are also regulations that govern appeals. So obviously you want to look at cost. You basically want to look at a cost benefit analysis. How much time will this take? And I always like to emphasize that potential benefit could be absolutely nothing. We've had a good track record of getting appeals settled in all that I've been involved with or know of. But there is always the prospect that you can file appeal and get absolutely nothing in return for it. So I will stop there, bring you in, Travis, and maybe before we go on to any of the technical, I'll let you comment on anything here, anything you've heard so far that you may want to comment on. But thank you for joining us today, Travis, and welcome. You're on mute, Travis.
Thanks, Patrick. Thanks for inviting me. And I know, probably some of the members that are on this are familiar with the work we've done in the past. And I just want to give kind of a high level explanation of the appeal process and start by saying that, if a provider believes that these rates are insufficient and inadequate for them to be able to provide the services, really the only way that you as a provider can challenge the rates is through this appeal process. If you do not file an appeal, you're going to get reimbursed at the rates as they were published. And it's just, unless ODP does something like they did the enhanced CPS rates and then made them permanent through COVID, but that's not something that they typically do. So if you believe that these rates as published are inadequate or insufficient, the only way to challenge them is through the appeal process. And the appeal process it's relatively straightforward. You initiate an appeal by filing what's called a request for hearing. It's the document that lays out your basis for the appeal, and it
Forgive me, Travis, but
yeah.
we'll advance the next slide. So
okay.
as we go through this, we'll keep it up here. We have
Yeah.
this. We have
and the regulations specify what has to be included in the request for a hearing. Some of it's pretty standard, just name, address, telephone number of the provider. But then the other specifics are the detailed reasons why the agency action is factually or legally erroneous. And the agency action that would be the subject of the appeal is the development of the rates, the publication and development of the new fee schedules. And, Patrick hinted at, we'd have to show that, or you would have to allege that they are factually or legally erroneous. And those are two different things. And I think, in the past, we've raised in the requests for hearing that we filed on behalf of a number of providers, what I would say are both factual and legal allegations of both factual and legal error. And Patrick and Tom touched on it. I mean, failing to adequately apply the Fair Labor Standards Act rule for overtime. failing to comply with the language of Chapter 6100 with the market-based approach, failing to properly failing to publish an adequate description of the methodology that's being used, things like that. And also, just argue that just as a factual matter, the rates as published are inadequate to provide the services. Now, the key is if a provider wants to appeal, the regulations are very clear that in instances where an agency notifies a provider of an agency action by any way other than mailing to the provider, right? So in this case, the way notice was provided was by publishing in the PA bulletin. So that's other than by mailing it to a provider. So if that's the case, an appeal or a request for a hearing commencing an appeal must be filed within 30 days of the date of publication. Now, the date of publication was August 31st, which puts the 30-day deadline to September 30th. I don't think it's a good argument, but there's an argument that could be made that it was actually available online the day before, on September or August 30th, which would make the deadline for filing an appeal actually September 29th. That's a Sunday, so really you would get until Monday anyway. As a, just out of an abundance of caution, I would say, I would look at it as the deadline to file the appeal is would be Friday, September 27th, just to make sure everything goes through smoothly. And if you keep in mind what we have done in the past for TPA members is we have put together, sort of a coalition where we have filed requests for hearing on behalf of individual providers, but then consolidated them for purposes of going forward. And we've done that under, a fee agreement where essentially all of the providers who have come together and said, we want to appeal these fee schedules would essentially split the cost. So, if we have a group of 10 providers, our costs would be split 10 ways. If it's 14 providers, it would be split 14 ways. If it's 2 providers, it would be split 2 ways. And that's something we can do. The regulations specifically allow for consolidation of appeals. Now they specify that each provider must file a separate request for hearing, but as long as the requests contain substantially similar or materially related issues of law or fact, consolidation it could be appropriate, and the Bureau can award it if one of the parties requests it. And typically what we have done is we have put together a motion where all of the providers who have said we want to appeal and be represented by K&L Gates, we put in a motion that say all of these providers request that the matters be consolidated. And I don't think we've ever had an instance where ODP has objected to that. In fact, I think we have, if not always, almost always submitted that motion as a joint motion for consolidation, because ODP, they want to deal with one, as one chunk anyway. The only downside to consolidation is when you move through the process in what's called the discovery phase, and I'll talk about that in a minute, the rules the rules contain limitations on discovery. For instance, for any appeal, a party can only file 10 interrogatories, and those are just written questions that a provider would file to ODP that ODP has to answer in writing. Each provider can depose up to 3 witnesses, but it's limited to 3. If the appeals are consolidated, if we have 10 providers and we consolidate into, all the appeals into one for purposes of moving forward, then the discovery limitations apply in the aggregate. So if you have 10 providers, you don't get to do 30 depositions. You still altogether get to do 3 depositions, 10 interrogatories, 10 requests for admissions. Now, I say that's a downside because it's limiting, but it's really not, because tactically, strategically, for each provider, I mean, frankly, because the appeals are so similar, each provider is probably going to, if they went ahead individually, depose the same 3 individuals from ODP, ask the same 10 interrogatories. So it really doesn't, I mean, we've never found that to be an obstacle that, prohibited us from moving forward in this manner. If a provider wants to appeal these, as I said, the way you commence the appeal is filing a request for a hearing, where you lay out, why you think the rates are improper, factually or legally erroneous. And then from there, it moves forward. ODP doesn't have to file an answer, but we move into discovery phase, where each party has an opportunity to get from the other party information for, proving or defending its position. The initial part of it's not really technically part of discovery, but we have to file initial disclosures, which is very straightforward. That's just who the contact person is, what the name of the provider is, what the provider's address is, information like that, and who who the provider believes has relevant information. And typically, in the past, what we've done is identified the CEO of the provider and the chief financial officer of the provider as that person, and then we move into actual discovery. And as I said, that's the process where each party tries to gather information from the other party. And the typical methods that we use are, we file interrogatories, which is a set of written questions that ODP has to answer in writing. We can depose up to 10 witnesses. So, we bring in, in the past, for instance, we've deposed Rick Smith as the designee, the corporate designee is the term we use for ODP. And we've, questioned him on how they came about, what process they used, what they did and didn't do, go through the different parts of the regulations that they have to follow, and what information they gave to Mercer, what information they got from Mercer, who was involved, and things like that. Then we move on to after discovery is closed. There's a point at which you file your position paper, where the provider files a kind of a legal argument of, this is what we intend to argue when we go to a hearing. Then the ODP follows with their position paper, and then if it gets this far, it gets to a hearing. Of course, all along this process, we're negotiating with ODP to see if there's an opportunity to settle this matter without going forward to a hearing. There's kind of sort of 3 phases to this for real meat and potatoes workload. I mean, the first is just drafting and filing the position paper. There's time and effort that goes into that. We would have to gather information from you as a provider, and determine what we're going to allege and what the harm to the provider might be. And then we move into the discovery phase. And then after that, we move into the get ready for hearing and hearing phase. And I think that's pretty much all I have to talk about on the in general appeal process. I don't know, Patrick, if you have any questions, or if any of the providers have questions.
Yeah, we'll get into some questions. We'll just go to the next slide. I think the only thing that we didn't display yet, Travis, was just, you've already covered this, but it's timeliness and perfection of a request. So you talked about the timeline. this is where it comes from in writing, a couple of extra days, online notification is really where the 30-day provision comes into play. And again, I'll remind everyone that we're not entirely clear about publication of corrected rates, but based on everything Travis has just cited, we know there was a publication on technically August 31. So I think we have to proceed with an operating understanding that, particularly for residential rates, there's strong likelihood. I mean, CPS, we have been alerted in writing that they are going to republish corrected rates. But if you're considering a rate that is not going to be corrected, then I think even more so, considering and really holding firm with the understanding that this is probably an end of September filing, and then there's some things that I'm sure we'll get into here in Q&A. So I'd like to invite any members to sort of post a question or raise your hand. I also want to invite in Daniel Green. Welcome back in, Tom Krofcheck. Just if you want to share your experiences. And I know there's a question that we received on the panel with respect to ODP not using a market-based approach. Is this something that violates the waivers? And Travis, you can probably read the question as well. I guess when I saw it, my reaction is it probably does need to be amended, because ODP does indicate in its waivers what their rate setting methodology is. However, implications, we have previously called out that there is no reference to Mercer or using Mercer in either regulation or the waivers or any place. So they have some latitude. My own understanding is that the waivers and CMS allow them pretty broad latitude in rate setting. It has to fall within certain criteria established by the federal government, but it probably would not be a difficult fix. Probably not anything that would face any opposition from CMS. And I'll add, it's probably a methodology I would personally prefer versus everything that we go through. If you've read any of the Mercer reports and you sort of see the flexibility that gets built in for the issuing agency to kind of take information and make it say anything that they choose. Again, probably back to there's an appropriation. We understand that. But tying to some type of inflation factor would at least give everyone some certainty in terms of what should that look like. So I will stop there. And Dan, let me start with you. I'll welcome you in. You've been involved in, I believe, several appeals over the years through TPA. So thank you for taking the time to join us. Is there anything you'd like to respond or react to, or just offer pro and con in terms of your experiences?
Yeah, over the last decade, we've been involved in a minimum of 4, technically 5 if you're counting the little one, appeals with you folks. And just want to speak on my experiences. There's a couple of things that this group has that I've seen that other groups don't always have. One is, Patrick, I just want to commend you. You're an asset to this group. The relationships you form, the knowledge that you have, and also being able to work with Travis and giving Travis that outlet to work with you is a huge asset to this group. Secondly, Travis in your firm has done a great job. The last several times that we've gone through you guys. Also, the general knowledge of TPA and Tom Krofcheck in general is awesome as far as being able to move forward and work as a group to get through these things. Though we may have many companies that do go into the appeal, in the past, they've been very responsive to the unique group needs and each company's unique needs. And that's very important to maybe some smaller or mid-level companies or companies that I operate with home and community a lot more than most organizations. So it was very important that both Travis, Patrick has been very responsive to our unique needs as a provider, and that's been very key. Costs have been kept down. It's been very helpful to be in this group. Having gone through this, about a decade ago, compared to some of the costs we've done going through the group, the costs have gone down as being able to do this as a group, and that's been very important. The last thing I say is we have had past success. That doesn't guarantee anything in the future, but doing this allows you to keep your options open. A lot of times these conversations happen and the first thing that comes out of their mouth is, did you file an appeal? And if the answer is no, that's the end of the conversation. And so by taking the initial step and getting in, it does keep your options open. And I feel that that's very important.
Daniel, thanks very much for your feedback. Appreciate that. And then thanks for touching on this. I did want to say a few words about the types of services you provide, just to give the audience a little bit of a feel for what you guys do.
So we're one of the few providers in the group that does most of our budget is home and community, companion. We do 100% CPS, those types of services. And so being, someone that's not purely 80% residential budget based, it's been great that you guys have been able to take the time and listen and work with us and still include us. And, it's been very, very helpful.
Thank you, Daniel. And please hang around if there's questions that come in. I want to encourage anybody that perhaps hasn't filed an appeal before to really take advantage of Daniel and Tom's experience in being members. Also, if you're in the appeal and you're in the group observing today and you want to make a comment, to just shed some more light on exactly what it feels like from your perspective. Tom, is there anything else that you would like to add?
Yeah, I can take the provider perspective at a higher level. I mean, I've been appealing rates for the last 11 years, and I'm pretty confident that anytime a rate setting comes out that has appeal rates, I'm going to take the position of appealing it, because you never know how long those rates are going to last for. We should all assume as providers that these rates will be in play conservatively for the next 3 years. So even if you're the provider who might feel like, hey, I might be able to make ends meet this year, or rates might be okay, or I don't want to incur the cost because it's going to exceed, my projected loss this year. You can't just look beyond, you can't just look to this year. You need to look, 3 years from now and say, is there any way possible that these rates are going to be adequate 3 years from now? And I think we have to look in the mirror and say, no, they're not. And therefore we need to file an appeal. In addition to the facts that the legal circumstances and regulatory non-compliance is really screaming, please appeal these rates. I almost feel like ODP and Governor Shapiro made that announcement and put these rates out there, such that if the General Assembly didn't do what they should have done and given us the 12% increase that they had said, at least the roadmap was out there. ODP was not required to put those rates out, and really did us a favor. And if you're on the fence and not sure if you should appeal, I mean, when I started doing this 11 years ago, I thought, man, this is crazy. It's a single payer system. The person who is your sole payer, the person who's your regulatory oversight and could cause so much nightmares for you if they chose to, is going to see that you appealed, and they could really retaliate upon you. And I could speak from experience over the last 11 years. I've seen no instance of any retaliation or, even anything negative in the slightest from ODP or the department relative to the fact that we as a provider have appealed. And I don't know that I've talked to anyone who's actually seen, any distinct retaliation for appealing. In fact, I believe the department expects that we will appeal these rates. So just wanted to throw that nugget out there to anyone who is on the fence, just to calm your nerves that I've not experienced, any retaliation.
Yeah, thank you, Tom. I appreciate you bringing that up. It is something that I often hear as well, concerns about that. And I think just to sort of underscore what you said, the practical experience is that ODP, it's part of the administrative procedure here. ODP literally will tell you in advance they expect to get appeals. I think it's just sort of part of doing business. But nevertheless, I mean, concerns on individual members, that's understandable. Talk to other members, talk to Tom, Daniel, others who might be involved in the appeal process. And Travis, I see a question has come in with Rick Smith retiring. Will he still be someone we can depose during discovery? I'll let you answer that.
Yeah, I want to address a couple of things in addition to that, and one is to really echo what Tom mentioned about the fact that conceivably these rates could be in effect for 3 years. And I know historically that wasn't the case. They used to regularly, republish every year until the implementation of 6100, and then the 6100 regs, gave them a 3-year window. So, if you may look at these and say, well, if we cut all the fat and get down to the bone, we can get by on these rates. You really have to ask yourself, yes, but can you do that for the next 3 years? Because that's conceivably how long these rates could be in effect until they do a relook. So that is important to understand. And the other is, I want to address Christopher's question about, if we're no longer using a market-based approach, are they also in violation of the CMS waiver? It's interesting because, as Patrick was going over the notice that was published in the bulletin on August 31st, it doesn't talk about market-based approach. In the past, they've specifically used that phrase, market-based approach, because that's what they have to do. Now, I would venture to guess that as we proceed, if any of you providers decide to go forward with an appeal, ODP is going to take the position that they did use a market-based approach, because they have to take that position, or they're admitting that they're in violation of their regulations, because the regulations specifically say, and I think Patrick had the regulations up. So we are, one of the arguments that we're going to be making, is no, you didn't. They're going to say, yes, we did. And we're going to argue that, no, you did a budget-driven approach or something along those lines, which is similar to an argument that we have in the current appeals. With respect to whether we can depose Rick with his retirement, I think the answer is probably. We can. You're limited to 3 depositions, right? And we can specifically identify individuals that we want to depose. Or the other thing you can do is you can say, we want to depose the individual who is most familiar with and can bind ODP on this issue. Now, I think in the past we have deposed Rick as sort of we noticed we want to do Rick individually, but they have also said Rick is the individual that's most familiar with, the promulgation of the rates and the development of the rates. Even though he is no longer a Commonwealth employee, because of his involvement in the promulgation and development of these rates, ODP could still designate him as an individual who, is capable of being deposed and binding the department. Now, they may have somebody else. I mean, because he's no longer an employee, they may identify somebody else who also can say, this is what we've done. I don't believe it would be Kristen Ahrens, the deputy secretary. I think it would be somebody, a little lower on the totem pole. Maybe, I don't know if, Rick has a deputy or somebody that worked under him. But we could also, it's a little different process, but we could also move to depose Rick as an individual, even though he's no longer an employee. So it is possible to get Rick's deposition testimony if necessary, even though he is retired.
So in the remaining moments we have, I just want to call out, we're probably in the last 5 minutes here. Craig, if you can just go to contact slide for Travis. I see some questions coming in as far as contact. We'll just leave this up while we still answer a few questions.
If I could,
sorry, I lost track of.
While you have that out there, Patrick, I forgot to mention, because of the deadline, and that's a hard deadline. If you don't get your appeal in on time, you can't appeal. If you could let me know, and you can, my cell phone, work phone, email, anyway, either way, let me know if you are interested in an appeal, and I'd like to get that preliminary information by this Friday, the 13th. So we can have an idea of who and how many providers are looking to go forward with an appeal. Sorry, Patrick.
Yeah, and I'll emphasize, please contact Travis directly if you are interested, want more information, because we will not do another informational session of this type at TPA. From this point forward, talk within your organization, talk to your board, whoever you need to speak with. to make that decision. I'm sure Travis would have consultation with you if you wanted some more information about that before you decided. But as we've talked here throughout the session this afternoon, it's a time limited type of activity. And if you miss the deadline, there's really, I would say, virtually no chance to be able to move forward after that. I'll reflect back on some of the comments and discussion since we started the Q&A session here. I think you do have to expect that we are still going to be, that ODP will be invoking regulation that we had up earlier. We didn't call this out, but they only need to do rate updates one time every 3 years. So they're not going to, as much as this commentary or the publication about rate setting methodology changing to an inflation factor, they're not going to be able to run away from that. So, that's good in some respects because, we can point out that you have a material flaw in overtime, and that's at a higher rate than what was published. So it will be able to take advantage of certain things that are published. ODP and the state right now are kind of straddling a line with backing into appropriation in a very public way after rates were published, not accepting comment on proposed rates, moving directly to final rates. And while that's good for cash flow for everybody, it's good to get everything secured. Those will be some arguments. Again, I don't want to get into them too deeply here. So I know we have a question about, do you need to show a deficit for a successful appeal process? Also, is there an approximate amount of legal cost each provider has incurred in past appeals? I understand it will vary due to a number of providers and the length of the appeal process. So I'll begin with the easy answer. Travis, please weigh in. Obviously, of course, number of providers and the length of time. Yes, absolutely, will affect cost. In previous years, it's been pretty formulaic in terms of sharing the legal cost. The distribution of settlement proceeds has really been simplified because they are based on claims. And the other thing that I want to add post-consolidation is that your individual information will never be shared with anybody else in the group. So I know great care is taken to make sure that your information, if we collect data, look at claims, that's aggregated many times in settlement negotiations, but in our group, and there will be regular meetings and updates to talk about strategy. And of course, at the discrete points in time when answers need to be filed and discovery is taking place and the position paper is being drafted. But absolutely, let me return to the loss argument. Absolutely no. If the argument is there's material reason the rates are lower than they should be, you do not have to incur a loss. ODP will often try to play it that way in settlement discussions, offering to pay up to your loss. But that, for at least the last decade, has really not been an approach we have taken in any of the appeals that we have filed. Travis, I'll stop there and let you respond.
Yeah, I would just second that. I mean, in fact, in the round of appeals that we have going on right now, of the 2022 rates, at various times, ODP has tried to impose a requirement on the settlement discussions that in order to qualify for a settlement, a provider must demonstrate an operating loss. And we, in representing the group of providers that we have consistently fought back and said, that's ridiculous. That's nowhere, there's nowhere in the regulations or the rules that say a provider has to operate at a loss. And ODP has backed off of that requirement. And I don't recall that being an element of a settlement in any of the cases that K&L Gates has done for the last several years.
Thanks, Travis. And Daniel, thank you for offering to answer any questions. The last question we had was really the process to begin the appeal. If filing a request for hearing, Travis, correct? So
yeah,
we'll let people contact you directly for more details on that. We've tried to provide an overview, answer any questions for today, but from this point forward, you have Travis's information. Please take that down. If you need to follow up, you can contact myself if you have questions about getting directed to Travis. So feel free to contact us and follow up. Thanks everyone for being here. Particular special thanks to Travis Geary and our other panelists, Daniel Green, Tom Krafczyk, and as always to Craig Douglas. Thanks everyone. Have a great day. We'll talk to you next time.